Today is Groundhog Day. It's a lot like our special election this coming Tuesday. Will we wake up with a different outcome that's resident first, or somehow be stuck in the same bureaucratic shadow? I'm Brian Costello.
And I'm Gregg Richards, and we are the Unselects. All right, Brian, we're less than 48 hours away from the February 4th special election. And as we've talked before, the deck has been stacked against the residents. And with only a day to go, they're still at it, right? And on Friday, we have this mystery letter that all of a sudden gets released by the EOHLC. And I think we really needed to do this special episode to be able to educate the public and let them know, what does that really mean? Does that change anything? And I know our argument is absolutely not. It changes nothing. If anything, I think it empowers the no side, and we'll kind of explain why. So let's take a look. I remember it was Friday afternoon. There was a press release from the town. It looked as though a new pope had been picked. The way that it was the way that they were announcing it.
Yeah.
A lot of fanfare.
White smoke.
Yeah. There was notifications, emails. So let's take a look at actually what went out here. So we're going to go here and take a look at the press release. So they did post this on the website, essentially saying that the EOHLC has determined that Shrewsbury zone is in compliance should we pass it at on the February 4th election. Should the yes prevail, that we're all set, everything's good, it can move forward. So looking actually at the EOHLC letter itself, it says, hey, we've made the determination after review. The EOHLC has determined that should Shrewsbury pass this and the yes prevail, that the zone is compliant. Now, there's things on here that are concerning. And correct me if I'm wrong, is there an enforceable guidelines? Is this law? Can you comply with this law?
There's no guidelines right now. As a matter of fact, the SJC said that the guidelines were absolutely unenforceable, and the EOHLC could not enforce any guidelines until there were enforceable guidelines.
Right. And the other part of this that I think bothered me more is, how did we submit for compliance? Because if we recall, yes, town meeting passed it. However, the referendum prevented them from submitting that for full compliance. So they're essentially claiming that we submitted a zone through an application, and they've determined that it's compliant, even though they weren't really allowed to do it because the referendum stopped the process. So let's go back and watch and listen to Stan Samia talk about that. If you look here, before we go into that though, just take a quick look at this letter. It says, once again, we determined that the zone bylaw meets substantive zoning criteria of Section 3A and 760 CMR 72, which are emergency regulations, by the way. I believe that's what those are. So it appears like we're moving along. So let's look at what John Samia actually said, though, so we know how this was possible.
Next item on the agenda is to review and act to authorize the chair to sign the district compliance application form. This item requests the board to authorize the chair as the municipal chief executive officer to sign the district compliance application form. This provides confirmation the town meeting voted to adopt the MBTA Communities Act, or MGL Chapter 40A 3A. We talked about this earlier. It's just to reserve our place in line. Should the referendum pass and essentially overturn the town meeting action, this would just be pulled out of line rather than wait. So that's what it's doing. That's all the request is, right?
So just to reserve our place in line in case the referendum passes.
Yes.
So I just want to stop there. I know that there's 78 communities that have submitted for not pre-adoption review, but actually submitted this district compliance application, who did vote at town meeting, and those zoning bylaws passed. Those communities submitted the process. Some of them had submitted things as long ago as December of 2023. They're still waiting through the process. So somehow, a town who's waiting in line jumps over 78 other communities at the EOHLC and gets reviewed and is deemed compliant in some form of miracle groundhog, maybe, some miracle groundhog event, that government efficiency just all of a sudden goes from 0 to 1,000. I mean, what am I missing?
Yeah, it's the magic letter out of nowhere. Just happens to be a few days before a special election.
Yeah.
And we have to remember that the EOHLC sort of pulled this with Needham as well. They did something fairly similar in Needham and said right before the election.
Yeah.
And so obviously the issue here is that the EOHLC actually has no power to actually tell people if they're compliant, because there are just no guidelines. And even emergency guidelines, if they were filed on the date of this letter, they're not technically even in power yet, because it still has to go through a process. You can't just say, I filed and therefore this is the law and these are the guidelines. The Secretary of State has to look at it. It has to go through a process. So it's kind of magical, isn't it?
Yeah, so here's my problem. Let's just go back and remind people of all the steps along the way in which the deck has been stacked and the town is doing everything in their power to get the result they want. Step 1, limit the campaign time and the time people have to be educated on the issue by scheduling the election as soon as possible, February 4th. Step 2, limit the number of hours people can have at the poll. Limit the polling from 2 to 8 p.m. so that there's only a short window for people to actually get out and vote. Step 3, you limit the options people have to vote by providing limited, if not any, notice to those who want to fill out an application for a mail-in or mail-in early vote or mail-in absentee vote. Step 4, you gaslight residents on how this is going to cost the town. We could get sued, we're going to lose grants, when that's not in fact true because the deadline's been moved to July. And then step 5, as we've just seen, you misrepresent the actions of what's actually happened, meaning, hey, we're just reserving a place in line, which we can actually say was complete lie. And I will say it's a lie, because if that was the case, you can't go through an application and be deemed compliant if that was just holding a place in line. And you're utilizing your position of authority here, right, to inflate the value of this information through this press release, causing many citizens to feel as though, oh, this is a done deal now. Now do we even have to vote?
Yeah.
Fair?
Yeah, it's very fair. And I think the issue there is the town obviously has taken a position and done everything it can to stop people from learning about this special election, certainly stop people from wanting to voice their concerns about this. And it really comes down to, I've said it quite a bit, common sense. There's no reason to act now because we have time.
Exactly. Exactly. So let's go look at the speeches we did at the select board. Actually, we're going to go to a speech I did just to reiterate the fact we keep going back to these guidelines and how important they are. So let's take a listen.
Proponents of the yes side, including this board, are pushing Shrewsbury to approve the action of town meeting, which was adoption of amendments to our zoning bylaw based on what the Massachusetts Supreme Judicial Court has deemed ineffective and unenforceable guidelines. Instead of respecting the court's decision, our governor and attorney general turned to political activism and created emergency provisions to push a political agenda.
So we're talking about emergency provisions and those ineffective and unenforceable guidelines. That I think is the basis here. And what we're going to pivot to now is we are going to talk a little bit about what the yes messaging is. I mean, we've given a lot of the no messaging, but we do want to go to the yes side. And one thing I do want to introduce, Brian, you are the chairperson of the No for Shrewsbury, correct? So
yes.
You'll be leading that effort. Now, the yes side is an individual named Beth Shea Bryant. And what I want to do is introduce the no side here to Beth Shea Bryant. And actually, to do so, we're going to go back to town meeting, and I'm going to let her tell you in her own words kind of what her belief system is around government and the importance that she gives it. So let's take a listen.
And I'm going to admit I'm pro-town government. I have the same viewpoints as a town manager.
Okay, so there you have it. So the residents on the yes side are being represented by somebody who has the same viewpoints as a town manager and loves local government. So the government is effectively, based on her own words, representing the yes side.
Yes, I'm from the government. Don't worry, everything will be okay. That's the belief system of a lot of people in town.
Yeah.
That have kind of go along to get along.
Right. So now we're going to go to, she did the opposing speech to you. I really appreciate Shrewsbury Media Connection gave each side time to present their case to the residents of Shrewsbury. So let's go to that yes speech and kind of hear the yes side's thought process when it comes to the guidelines themselves. Let's take a listen.
It is important to understand that these guidelines were set aside for procedural reasons only, and the court did not take any issue with the actual content.
100% wrong.
Yeah.
Not only 100% wrong, provably wrong, with a very, very simple reading. If you actually read, I would encourage the SI to read the Supreme Judicial Court ruling and actually take a look at it, because if you look at it right here, what does that say, Brian, highlighted?
We need not reach whether the existing guidelines are consistent with the Act.
And why do they say that?
Primarily because it's not important to them in that sense. It's basically saying the guidelines don't exist right now. We've ruled that the guidelines are not in effect, and they aren't. It doesn't matter about it. It's factually and legally not able to be, even enforced.
So I just try to simplify for those non-legal scholars out there, which is most of us. Essentially, they said, since you didn't follow a process and the guidelines you gave us are no good, we can't even look at the validity of what's inside of them until you correct it.
Yeah.
So when they're saying that they found nothing substantially wrong or it was only procedural, it's not correct. They didn't look at them. So just to be clear, right, correct if I'm wrong, from my legal advisor here, when properly promulgated regulations are in place, Milton could go back and go after the substance of those, and the Supreme Court would then look at those and make that determination.
Yeah, actually, the process is the APA or 30A.
Yeah.
The municipality or citizens can actually sue against the guidelines. They can say these guidelines are inappropriate for whatever reason. It goes to the Superior Court first. The Superior Court hears that, and then if there's a ruling, either side could actually then appeal it to the Supreme Judicial Court. Okay. So again, it gives a process. So to your point, the EOHLC tried to pass guidelines that were just like, here you go, you're bound by them, you're stuck with them.
Right.
Shut up and sit down. Actually, what the Supreme Judicial Court said is, wait a minute, you shut up, create the guidelines, and then, oh, by the way, you can get sued every day.
Right. And then come back, and then we'll make that determination.
Yeah.
So that hasn't even been found out in court yet. So that's the first part that we're going to point out here. Second statement here, let's go back to the yes side, and this regards the emergency regulations. Let's take a listen.
The governor has put in place emergency regulations which in effect continue those guidelines while permanent guidelines are developed. The administration has stated very clearly that these guidelines will closely mirror the prior ones.
Okay, saying that the emergency guidelines will closely mirror them and that everything's okay, have no fear, they put in emergency regulations and it's completely fine. The problem with it is, I think, as residents, and this is where I think we're coming from and differentiate maybe from the yes side, is we need to question the government and we need to scrutinize. We shouldn't just take everything at face value. We saw this with COVID about overly restricting citizens' ability and taking away freedoms because of quote unquote emergencies. And we got to be very cautious when we do that. So let's take a look here. And what I want to point out is this is the actual copy of what was filed. This was FOIA'd of the regulations, emergency regulations filed with the Secretary of Commonwealth. And if you could read there, Brian, what does it say there highlighted in yellow? Because this is when they're trying to define, let me predicate this. They're trying to explain what the emergency actually is, because you have to define that when you file an emergency. So if you could read the yellow there, what is the emergency that they claim?
Absent this emergency adoption, there would be no regulations in effect which the EOHLC finds would be detrimental to the general public welfare, including but not limited to the interests of municipalities and others that have relied on the guidelines.
Yeah,
which is kind of double speak. You relied on guidelines that weren't promulgated correctly.
The way I take it is this. This is the craziest argument I've heard. Like, this is where common sense has to come in, right? Think about this. What they're saying is, we screwed up and we forced and cudgeled based off of pressure and threats.
Yep.
Towns to comply. Those towns who complied, it would not be fair for the towns that complied to actually have to get different regulations or wait for us to follow the proper piece, because that would be unfair to those who we improperly forced to comply in the first place. So it's like our fault. It's a self-created emergency.
Yeah.
I mean, am I reading that right? It's like we created this emergency, so you need to allow us to file regulations to fix our emergency that we created. It's amazing.
We put a gun to your head. It turns out the gun wasn't loaded, but wait a minute. Let us take some time so we can put some bullets in there and take away all of your grants in life.
I also want to discern how is it detrimental to general public welfare not to have guidelines in effect? I mean, that is just it's unbelievable what they keep doing here today. So that, as you can see, it's not a real emergency, and we shouldn't treat it as a real emergency. And this is actually, there was a Superior Court filing actually on Friday from citizens challenging the validity of that. So we'll talk a little bit about that later on here. So let's keep moving on. Last piece here is we're going to go back to Beth Shea Bryant to talk about remedies and fear. So this is of course that fear-based argument that they're going to give us. Let's listen.
By rescinding 3A zoning plan adopted by town meeting, Shrewsbury will move towards violation of the law. The SJC has held that the law will stand as constitutional, and the Attorney General can sue Shrewsbury for noncompliance. The Attorney General's lawsuit against Milton outlines possible remedies she might seek in court.
Okay, outlines possible remedies, but I don't think that they've actually done any remedies in Milton because they still have until July 16th to figure something out. And that's just not me saying it. Let's actually listen to Kevin Mizikar will actually say, is there anything that has been done to Milton or what's really the status of Milton? So let's take a listen to Kevin Mizikar.
I mean, there hasn't actually been any enforcement mechanism in Milton yet to compel them to do one thing or another.
All right, so as Kevin stated there, Milton, who's the first town, filed the referendum, was part of the case with the Supreme Judicial Court. Even after that, there's still no remedy. They're not coming back after Milton because they have until July 16th. So there is no harm in waiting. We have all the way until July. So I just don't understand what the fear is about how we're going to go get sued. They're not going to sue the town because they can't.
Right. It's just a boogeyman that they're trying to push out there. But the reality is even the AG has said you have until at least July, which might shift, by the way. It might be later, but at least till July. And she has even said she wants to work with towns to come up with the right solution.
Right.
Right? She's not going after Milton. She's certainly not going to come after Shrewsbury because guess what? We are at no risk of being non-compliant.
Right. Right. So another topic that I've heard out there, a lot of people are using, I think maybe to dissuade people or complain about the referendum process is the cost of the election. So let's listen to Donna O'Connor, somebody who was actually the select chairperson back in '95 with the first referendum vote. Let's listen to her on Ask the Manager making claims about election costs to the community.
It's costing the town over $50,000 for this election. Mm-hmm. So people weren't happy with the Beale project. Mm-hmm. That cost the town $100,000. Mm-hmm. And now over $50,000 for another election because people didn't like the way town meeting members voted. Mm-hmm. I got that right? Mm-hmm.
Looks like she's looking for a ride somewhere. I think what she doesn't understand is that citizens actually have a right to question their government. And I don't think 50,000 is the correct number, but ultimately the select board actually has said the cost of this election was never a concern for us.
Exactly.
There was no even conversation in select board about the cost. They realized that citizens took an action. The town has to comply with that action, and we'll see the results.
Right, and I believe even Kevin Mizikar, let's go back when they picked the date of the election, and there was a remedy to avoid costs.
There was.
Let's listen to what he says.
There will be a cost to this, so co-locating it on a special town election ballot would save any extraordinary costs associated with running a special election.
So once again, the select board made the choice. To your point, they weren't concerned with the cost because if they were, it was the select board's decision. They could avoid at all costs to co-locate this question on the May ballot, which now, after everything that's transpired, would have been the most prudent choice. And they would have looked, actually, I think very favorably if they would have made that decision because we could have said, look, we saved the cost. The SJC ruling is out. Now we have more time. We can wait for the guidelines. Good thing we picked May.
Yeah, we've been just incredibly foolish as a town when I say foolish, I specifically mean bureaucrats, political officials, not looking at the long term, not consistently just rushing down the street with their eyes closed in traffic. And it's just unbelievably frustrating, I think, to an average citizen to say, well, we could have waited. We have till July. Even with emergency regulations, we have till July. I just don't understand who's benefiting from having anything happen this quick. Makes no sense.
Yeah. And what I think, what was the other point we were making too? If you looked at when you say, hey, if we wait, you know, what's the process again? Because we're advocating, it says we say no now, then what happens?
Right.
Right. We have 2 opportunities, 2 town meetings, which if there's effective enforceable guidelines, which we can comply to. Now, I believe Kevin Mizikar says exactly the same thing, and I'm going to go to him from Ask the Manager again because he walks through what that process is, which is exactly in alignment with what we've articulated. So let's listen to what he has to say.
If there is a no vote, that we are going to have to bring additional legislation back, likely at the annual town meeting, to once again try to get in compliance.
Well, the problem there is get into compliance with what?
Right.
There has to be guidelines. But yeah, his point is taken.
So let's assume that there is. He's making it out like, oh, we'll have to go back. We're like, so?
Yeah.
Okay.
Because what if the guidelines change?
Exactly.
You know, and I think that's the key is nobody really knows what's going to happen with the guidelines because, as we said earlier, it's almost negligible that they actually won't change in some substantive manner.
If they do it correctly, I would agree with you.
Yes.
Yes. If they don't, but there's a lot of politics involved, as we've seen, and people do not like to feel embarrassed or proved wrong. So oftentimes, you know, that's a bigger factor than actually respecting the will of the people and serving those who are essentially paying for you to be in the roles that you're in.
Yeah.
So now let's kind of go back. We wanted to at least walk through how we got here in the first place. I think it's important to know. And when I mentioned earlier the steps along the way to limit the voice of the people, let's just go back and go through those again one more time for everybody since we're so close to the election. So let's go back and listen about the recommendation on how did we get the February 4th date again. So let's remind everybody how that happened.
My recommendation to the board would be the February 4th, 2025 date. I think it strikes a balance of expediency in resolving the matter.
Expediency. Got to go fast.
Right. You got to resolve the matter, right? Expediency in resolving the matter, which didn't give people a lot of time. And obviously, we've even seen it, right? There's struggles in the wintertime.
Yeah. And, you know, other folks even admitted that this is a complex issue. It takes time. I think the select board, the folks on the select board, they sort of said, well, you had all the time in the world, right?
Well, they keep going back. We've been doing this for 2 years.
Yeah.
It's kind of like one of those things, like people, they can't expect everyday citizens who are going about their day and trying to work and provide for their families and trying to figure out how to deal with all this additional inflation and where some of the money is coming in, and then look at nuances of zoning. I mean, that's why they're in this position. And in the part, I think the reason why we've done this from the beginning on the Unselects is we're trying to provide the same information to the people in a format they can consume.
Yeah.
And that's where I think the town could do better. They need to be able to explain things and allow them to digest the regular everyday citizen so that they can really understand what the impact of all these decisions is.
Yeah.
And that's just something I don't think they've spent enough time doing.
No, I agree. I think it's been, I know they don't think it's been rushed, but this whole process after 1,800 people signed for an election was certainly very rushed.
Well, not only rushed along the way, let's actually listen to, I think, a perception that the select board wanted to make sure, because there is a lot of chatter out there on the social media about suppressing the vote and things that they may or may not have done. So let's listen to Teresa Flynn and that comment that she made, I think, in the January select board meeting.
To every resident, we hope you go out and vote. Anyone who says that we are trying to rush this so we don't generate voter turnout, that is not my position at all. And I just would encourage people to find their source of truth and, determine who they trust to give them accurate information. And that might be one of us. It might be someone who is an opponent, or maybe someone in the middle.
I would say on the surface, just the date of the election, maybe you could say, okay, that maybe you're not really trying to suppress the vote with that, or that, that's just a date they picked. But it's multiple things. And the next one that we're going to talk about is that the 2 to 8 p.m. And there's been a lot of confusion about, wait, where does that come from? And just remind people of where it comes from. And we'll go back to town council and have him explain it again.
One last quirk, if you will, or interesting aspect of Section 16, it sets the hours for the election of 2 p.m. to 8 p.m., which is different than in the general laws. The general laws prescribe hours for, minimum hours for a polling place to be open for election of town officers. And I wasn't certain if that would be applicable, if it would override, the general laws would override our special act, but I confirmed with the Elections Division of the Secretary of the Commonwealth's office that the special act governs the referendum election. So the hours of the polls will be 2 p.m. to 8 p.m.
Now, we've covered this before.
Yeah.
We talked about it. We're going to go through it again quick because I think it's important, because he mentioned there that he wasn't really sure, because we've never done, the referendum hasn't happened in 30 years. So if you don't look at the document, even as an attorney, you got to back and review. And he's not a specialist in elections. I think he's more of a real estate property type attorney, right, that represents clients who are going to go in front of the planning board or zoning board of appeals, those types of things. So let's go back and look, because we did actually FOIA the emails here. And, our argument along the way, right, is that the way that this was framed, or the way that you actually are advocating and framing your questions, could have determined the outcome.
Yeah.
Because if you look at how this was raised, he essentially says, hey, it is my understanding that there's really no way for us to change this, that we have no flexibility. But correct me if I'm wrong, right? Essentially is how he frames it. So he goes through and he says, hey, it shows here the polls are open at 2 p.m, closed no earlier than 8, and that he did not find a provision that required them to be open longer. Instead of saying, is there any place you could see that would allow them to be open longer? Because it would be great if we could allow them to be open longer, because to me this doesn't seem fair to residents. And then he keeps going, right? Then it says, well, I also see Mass General Law, Chapter 54, Section 64, where it does actually allow the selectmen to set the hours, and they can make the hours the same, is what it says, as on a question that would be for the voting of actual town officers. But then his conclusion is, in his view, that we have to follow the 2 to 8, and we're not allowed, and there's no flexibility. But let me know if you disagree with my determination.
Yeah.
We talked about this, and I said, well, okay, as an attorney, right, if you would have said, I believe that this other chapter allows us flexibility, we can change the laws. I think we're going to schedule the election from 7 to 8 like we normally do. Please let me know if you disagree with that.
Yeah.
And let the professionals, or let the experts, I didn't say the professionals, he's a professional, but let the experts in elections, which would be the Secretary of Commonwealth, tell you you're wrong, and force them to say, no, you're wrong. Because when I called and talked to them, they said, we defer to town council, because they're going to know that local thing better. So if town council would have advocated, I'm very high probability that we'd get a different result.
And I also think the way it was framed, as you said, is framed in a way that we don't want to change this because it would be bad for us. Mm-hmm. And therefore, I'm never going to ask that question, right? So to your point, framing it as such that this is what we have, but to be voter first, to be resident first, there looks like there is an opportunity in the Mass General Laws that the Select Board can change those hours. We would love to be open 7 to 8. Do you see any prohibition to that?
Exactly.
The state comes back and says, absolutely not, 2 to 8, that's the rules. You can change your bylaws someday.
Right.
Right? Okay, fine. I would accept that, actually. But there was no, again, not resident first, bureaucrat first.
Right. I would have advocated for the residents and let them tell you that you're wrong and have to do it a different way.
Yeah.
I mean, there would be no harm in asking
Yeah.
that. So the next thing that they did in that special act, it's a different special act, which we're going to talk about. There was actually a post on Facebook I saw, and there's people that were concerned, and I actually saw this myself, is that the voter guide in which you wrote the no argument.
Yes.
Each side got to write 250 words, and that voter guide is mailed out to every household in Shrewsbury prior to the election. And we had to submit that, or you had to submit that, I should say, on January 6th.
Correct.
The voter guide was received by many people on January 28th. And the reason I know that is because that was the deadline for mail-in voting. And a lot of people said, wait a minute, I just got this document, which we're going to show you right here on the screen, that states that the last day to apply for absentee or early voting was the 28th.
Yeah.
And a lot of people had posted and said, I just got this on the 28th. So apparently, I guess I don't have the opportunity to do that.
Yeah.
So, to me, we had to kind of go back and look, and let's walk through, how this came to be as far as what that schedule and the deadlines, and was the town, and this is another thing we're going to talk about. Is it I'm following it to the letter of the law, or am I doing what I think the law is intending? And I think in this particular case, they're following to the letter so that nobody can complain about it, but it's really not in the best interest of the residents. So let's take a look. Beth Cassavant in Facebook, and this is a point we want to make before we get to that initial piece, on this complaint was, well, it's not a big deal. This was it's not a big deal because, the reason why this act was put in 2006, social media wasn't a thing, not as much electronic communication, so who cares? There's other ways to be notified, emails, social media posts. So to say that this was the only way people knew to register is she's essentially trying to minimize it. One of the things I do want to show, though, is she should probably talk to the Yes person, the chairman of the Yes committee, Beth Shea Bryant, because Beth Shea Bryant at town meeting, which we're going to go back to here, when I was advocating for being an elected planning board and the cost impact of an election was discussed, and I had said, well, you know what? I think nowadays we could probably use electronic means a little bit better and probably help mitigate some of the costs and get the messaging out, and you don't have to spend a ton of money.
Yeah.
Well, let's see what she says about relying on electronic communication when it comes to voting issues. Let's take a listen.
All votes are important, and I know, Mr. Richards, you made the comment about digital outreach to people. Not everybody has that access, and everybody has the right to get information on a candidate and to be able to have that interaction with them.
Right, everybody has the right to get this information?
Yeah,
Not through digital?
That's right, because not everybody has it.
How could they possibly get it?
That's
Maybe
what I mean.
by mail?
I know. So I think the Beth should have a talk and maybe communicate and say, I appreciate the fact, Beth, that you think that electronic communication, but as Beth Shea Bryant says, a lot of people don't have it, and every vote is important, and the voters have a right. So, I'm waiting for...
Unless you're a voter that might want to vote no.
Right.
Yeah.
But to be consistent, maybe Beth Shea Bryant could respond to Beth's Facebook post and suggest that, Beth, I understand what you're saying, but every vote is important and not everybody has access to digital. So we'll see if she does in the next coming days. So let's actually go back and listen to John Samia. He'll talk about the voter guide and what they're actually required to do by this statute, and we'll see if they've met the threshold of what they're supposed to do as a town.
Next item on the agenda is to review and act to select a principal proponent and principal opponent pursuant to Chapter 427 of the Acts of 2006 for the question on February 4th, 2025 special election ballot. As we set December 17th, that proponents and opponents, the deadline was noon on yesterday. What the Act requires is that we select a principal proponent and principal opponent. For question 1, the written arguments by said proponent and opponent will be included in a voter guide sent to all registered voters at least 10 days prior to the election.
Okay, at least 10 days prior to the election, sent 10 days prior to the election. Now, when was the guide actually sent in this case? So we're going to go back and we're going to listen to Mr. Garcia, who's going to ask Mr. Dobson when the guide was sent. Let's listen.
Do you happen to know when voters should expect the voter guide in the mail?
The voter guide will be mailed out this Friday, the 24th.
Okay, it was mailed on the 24th. 11 days before the election, because it's a Friday. So it's the absolute last day to meet the statutory requirement. Let's go back on the timeline. They had the 250-word pieces on the 6th. They didn't mail it till the 24th. So keep in mind, from the 6th to the 24th, what also came out? The SJC ruling.
Correct.
Could you update your 250-word messaging?
I could not.
You could not. So we couldn't update the 250-word messaging to be more relevant to the voter, but they could take almost 20 days before they mailed it, just so there was minimal time before the election in which voters had to, number one, register and submit for early voting and absentee voting by mail, and have time to digest and read into something. So once again, another way to just barely meet the threshold.
Yeah.
And it says, minimum. So why do we have to do minimum? Why can't we say, you know what, I think we should have it maybe more. Maybe we should, why not 14 days? Why not 21 days? You had the guide. How hard is it for you to print it and send it out?
Yeah, well, it's just, again, using the word expediency. When they mean expediency, they mean letter of the law. Mm-hmm. Do not give people the opportunity to learn anything. Mm-hmm. And, obfuscate and block as much as possible. It's either intentional or, gross incompetence.
Yeah.
Personally, I think either one of those is not a good outcome.
No, and they talk about trust and transparency, and they even talked about that on Facebook about the letter and say, well, if we wouldn't have sent the letter, then people would have questioned the transparency. And I just don't understand how they don't understand it. It's because it's so one-sided. Because I'm going to go back and summarize this again, just so we can be clear, so I'm not wrong. I mean, I'm talking from the beginning of this MBTA process. It's important to know. So if we go back to the beginning, let's just review. The town originally had picked a zone, Christmas tree shop area. They had to submit, because there's a mandatory mixed-use provision there with commercial and residential, to the state on that. They got rejected.
Which we predicted. And we were told we were crazy for saying that.
And they did not tell the residents before town meeting. There was no press release that they received an HLC letter on Monday. There was no post to Facebook. There was no email, right? They didn't tell anybody. They didn't tell anybody until June. This was in May.
Right.
Then the planner comes and says, oh, by the way, the zone was rejected, but have no fear. Without input from the community, we've changed the zone and we've resubmitted it for pre-adoption review.
Here's a whole new zone.
And we can't talk about it for 90 days. So we appreciate the fact that we didn't give you an opportunity to comment, but trust us, this is what we want to do.
Yeah.
Fair?
Magic spreadsheet.
Am I going?
100% correct.
Okay. So we did that to the residents, didn't tell anybody. Now they finally get pre-adoption review back for this specific zone. Then, we actually go to town meeting after a bunch of discussions there. We put in provisions in the zoning bylaws which allow special permits to go bigger than what we needed to, even though they said we're only there to aim for minimum compliance, which was not true. We add a provision in there that allows us for fee in lieu for affordable units, which then we're using the affordable housing as the mantra, which we're giving people an out.
Yeah.
Fair?
Yes.
So I'm good so far. Just correct me when I'm wrong here. I don't want to seem like just too one-sided. So, all right. So we go to town meeting, right? And then they put in this whole thing to protect Beale, which the amendment gets thrown out, which we're not going to get into today. And the zone passes, which they claim, right, is this mandate by town meeting because it was 123 to 50. But what they don't tell you is what about the 67 town meeting members who either were not in attendance or didn't vote on it? But yet somehow they represent the public. Well, 67 out of 240 don't show up. They're not representing the residents. So we go out, Brian, you led the effort, go out and collect signatures on the referendum, which you were able to get well more than the threshold. 1,700, 1,800 residents said, yes, you know what? I think we should have the ability to weigh in on this.
Yes.
So they go in there. All right, when that's filed, they say, well, we're going to give the residents the minimum of time to think about this, and we're going to schedule this election as soon as possible on February 4th. We're going to limit the time you have at the polls from 2 to 8. Then we're going to limit the amount of time people have or notice that they have to actually register to do mail-in voting and everything else. Then we're going to keep gaslighting you on how this is going to be detrimental. We're going to lose all this money. The schools are going to have to shut down. I'm being dramatic there, but yeah. Those types of things, right? And then they sent out a letter that essentially the last 2 days before the election effectively, letting people know, essentially trying to show them that, hey, by the way, this is already a done deal, so don't even bother to go out and vote. So it's instance after instance after instance, and they wonder why people are frustrated right? Why are we frustrated? Why do we think there's not transparency? I just laid out the case to why we don't think there's transparency.
Yeah, 100% accurate. The problem is if you want transparency, you actually legitimately have to be transparent. And we've seen that time and again that that's not the case. I take it a step further. That letter that came in on Friday somehow gets sent out an email, put up on Facebook. Yet, to your point, when they got the compliance back in May,
Nothing.
they just sat on it forever. And by the way, their excuse oftentimes was, oh, I didn't see it. I mean, the town manager sort of said, oh, I
Well, actually, I forgot to mention something, because you're right. They didn't see an email, and the reason why the pre-adoption review was delayed and they had to have a compressed schedule for the planning board hearings, which is another point I forgot, was because they didn't submit data back to EUHLC, causing a delay, impacting the residents and minimizing the time we had because of their own internal error.
Yeah.
And they didn't want, they finally admitted that, Kevin Mizikar did. So one last lack of transparency, and I'm going to go to this here, and I'm going to listen because the select board is claiming, we asked in our speeches when we went in front of them, they said, you know what, based off of now these new updates, the SJC ruling, non-effective guidelines, deadlines moved in July, we think you should vote no, or suggest vote no. Let's listen to Beth Cassavant talk about it, and there's going to be some things on the screen of showing how it's a little disingenuous to say what she's saying. So let's take a watch.
And just one other thing I want to note, we were asked in the public comment period, to, urge the town to vote no. It is not in the purview of this board to be urging yes or no.
Next question under new business, colleagues, is to review and act on whether to take a position on the question on the February 5th, 2025 special election ballot.
I think we need to take a vote on it. We recommend warrant articles. We take hard votes all the time. We've voted on this multiple times. And I think we should just, one more time, affirm that we see this compliance and upholding the vote of town meeting as the path we would recommend for Shrewsbury.
We took a vote and we said where we stood on it, but there are two ballot committees, and there's that division between public resources, public boards, which is what we are, and then a campaign, which is what we're not.
All right. Now, Beth Cassavant is 100% right to choose a side and say that she believes that yes is the right way.
Absolutely.
I'm not saying she doesn't. But don't pretend like you don't have a position. Just own it. If you're like, hey, I think it's yes, this board should vote yes, I'm a yes. But this whole wishy-washy thing about, oh, this board doesn't take a position, it's not true. I mean, you have a position. People know your position. You're representing the board on Facebook. You can say that it's you personally, but you represent the view of the board. People view you in that way and say, well, this is the select board is suggesting we vote yes. The select board is telling us to do this. She can't separate the two. So just own your position, Beth. Just own the yes if that's the way you believe is best. That's totally fine. I don't fault you for that. You're allowed to do it. But just don't tell people that you're not.
Yeah, I think that's the key. It's sort of like you have every right to have a position, right? But when we asked about the no, which was absolutely in the best interest of the town based upon all the facts we currently have, the idea that, oh, we don't take a position is sort of just a BS response.
Yes, it is. So finally, I know we've talked a lot about what the barriers that are put up in front of the residents, and the way I wanted to kind of close this is you did a great job. I encourage everybody to watch it. The freely speaking, Brian gave the no position, but just want to go to a short clip here of Brian just to try to summarize why we think the no makes the most sense, why it's the rational, reasonable choice for the town, and why we believe that if you really think that the Shrewsbury residents should have a voice, no is the way. So let's take a listen to Brian here.
Who benefits from having a risky zone created before any guidelines and over half a year before we're required to? It reminds me of an analogy. This is like actually going to the doctor and getting a brace on your arm, a cast on your arm, because you think you might break your arm in July. It makes absolutely no sense. You don't benefit. Our schools don't benefit. Your kids' class sizes don't benefit. Our congested roads don't benefit. So ask, why now when we have so much time? Are we that eager for developers to just swoop in? Do we really want to risk it, especially when we have plenty of time? A no vote means you benefit. Our schools benefit. Common sense, for a change, wins the day. So we're just asking for the vote no on Tuesday, February 4th. We hope to see you at the polls.
Everybody get out and vote 2 to 8. NoForShrewsbury.org if you want more information. Contact at theunselects.com if you want to ask us a question or send us a message on Facebook. So with that, I'm Gregg Richards.
I'm Brian Costello.
And we are the Unselects.